May it please the court, Joe Eagleton with Brannick Berman Insider, joined at council table this morning by John Spar with Brock McLean Spar, here for the appellants and cross appellees, Cypress Midway, Broadmoor Enterprises, Broadmoor Ventures, Fortaleza Storage, Manchester Commercial Lending. If I didn't already use up all my time with that long introduction, Judge LaRose, I'd like to reserve 5 minutes for. Thank you. When Cypress Midway purchased this property from the Dahl Trust in 2021, it relied on the language in the 2015 lease between the trust and the appellee Superheat to define the scope of Superheat's rights. That lease includes two relevant provisions that the trial court here failed to enforce. The first is a broadly worded subordination clause. This is paragraph 9 of the lease, and it makes all rights, privileges, and benefits of the lease subordinate to any future mortgages and liens on the property. This clause expressly said that the lease, the purchase option is one provision of the lease. It's contained within the lease. This subordination clause said that Superheat's rights under the lease are subordinate to the right of the property owner to put a mortgage on the property.
So, and I know that's your position, so I would be pleased to argue the 2015 purchase. Someone has priority. I
think, Your Honor, our response is that the language of the lease with the purchase option is a provision within it controls. And so the language of the document where the purchase option is included within it has a subordination clause. And that clause, I mean, I don't see frankly how it could be much clearer. It literally says, it is specifically understood and agreed by the parties hereto that this agreement and all rights, privileges, and benefits hereunder are and shall be at all times subject to and subordinate to the lien of any and all mortgages and the accompanying documents, etc. It even contemplates a mortgage recorded by a purchaser of the property, because in the first sentence of the subordination clause, it says, this lease is expressly made subject to and subordinate to all current or future mortgages and liens upon the premises or any part thereof by the landlord or its successors, including purchasers.
So the fact that it says future mortgages very clearly in the lease agreement to the argument that the purchase.
Yes, Your Honor. I think that, the Superheat has cited some cases that discuss sort of general order of priority of liens, but those cases don't have the language that we're talking about here. So Superheat acquired its purchase option here in the same lease agreement, the same contract that includes this provision that specifically says a future mortgage is going to have priority.
And that, so I understand the case like your ability to exercise a purchase option is sort of encoded until you indeed exercise.
That's correct, Your Honor. Yes. And so, at the time that Cypress Midway purchased this property and recorded a mortgage, Manchester Commercial Lending has a mortgage on this, it's recorded, the purchase option had not been exercised. And so at that point in time, under the language of the subordination clause, the mortgage takes priority over the purchase option. Again, I don't know what this language frankly means if it doesn't mean that the mortgage takes priority.
Interested in the short shift in the latter portion of that provision. The latter portions of the subordination shall be self-operated. Use of subordination shall be necessary. And there's the tenant wants to shoot their officer back. This is possible that suggests it's just typical provision in the lease that requires the tenant to allow, a change in ownership of the landlord, letting take place with the property as a lien, and that is support to the ability, their position that this does not apply to the purchase option, but rather is just typical landlord tenant provision that only applies to the leasehold rights.
Well, I don't think they quite made that argument under.
No, I think Frank, the short trip didn't address that provision.
Sure, Judge Atkinson. It's possible that that language could have been included to contemplate a situation like that, but the clause itself also does refer to purchasers or transferees and the landlord or its successors, and it refers to future mortgages. And I don't actually see how the argument that they're making, Superheat is making, as to Cypress Midway's rights under to mortgage the property is really any different than the argument they'd be making as to the Dollar Trust, the original owner. I mean, they're arguing that they basically, once they acquired this purchase option in the lease, that it has somehow priority over any mortgage that's going to be recorded. I don't really see how Cypress Midway is any different than if Mr. Dahl had taken out a mortgage sometime after 2015, on the property through Bank of America because his ailing mother needed home health care or something like that. I mean, that's their argument would apply, I think, the same way to that versus this. And I realize that sounds like a different situation, equitably maybe, than what we're faced with here. But the language of this provision, I think, is really clear. It talks about transferees and purchasers. It talks about the landlord or its successors. And if the parties had wanted something different, then I think they could have negotiated something different here. They clearly contemplated in this language that a future mortgage would have priority. And I think
Well, that raises a point for me. In your research, have you found that that kind of provision is sort of like the default rule? And that if the tenant wants a different deal, you negotiate around what would otherwise be the default?
I'm not sure either side has cited a case with language exactly like this, Judge LaRose. I mean, obviously, the law is that the parties are free to contract around default provisions generally as they see fit. I think that what we have suggested is the cases that Superheat has cited are cases that don't have language like this. And so they have not pointed out any case with language like this where the default rule has still been applied, I think is our position on that. And I think too, the trial court's judgment said something I thought sort of interesting about why, the court was declining to enforce the subordination clause. The judgment actually says that it would quote unquote effectively invalidate Superheat's purchase option, and that would be wholly inequitable. And I think that first of all, just misses the point. I think it's also inequitable to grant Superheat rights that it did not have under the lease, and to say that, Cypress Midway was not entitled to rely on what this lease said when it paid $1.8 million to buy this property. But, it's also, I think, not true, right? Superheat had a choice about whether to exercise this purchase option. No one forced them to do so. They admitted at the time that they originally exercised it, and then again at trial, that they still want to exercise the purchase option, even if the mortgage is enforceable. So apparently it does not, in fact, invalidate their purchase option. And, all the uncontradicted evidence here as well was that undermining the purchase option had nothing to do with why this mortgage was put on the property. It was Cypress Midway, when they purchased this property, thought that the lease was about to expire. They never actually contemplated that this purchase option would come to pass. It was unfortunate timing that this Dahl passed away within the 4-month window between the time that Cypress Midway acquired the property and Superheat's purchase option was set to expire.
Don, the timing is interesting. What another aspect that's interesting is that that Superheat negotiated an option to purchase, and it negotiated it as subject to Ms. Dahl's death. Yet the property owner decided to sell before Ms. Dahl's death. That's interesting. But do you think that it makes any difference to our analysis?
I don't think it makes any difference.
Is it interesting that the landowner negotiated that it wouldn't be sold to the entity that had the right to purchase it until she died, and then it sold it before she died?
Well, I don't know if interesting is the word, Your Honor. The evidence was that the prior owner of the Dahl Trust was worried about some tax consequences of selling the property while she was alive. And, Cypress Midway paid.
I think the concerns I raised, he had a concern about a step up in base.
Correct, Your Honor. Correct, Your Honor. And so Cypress Midway paid more for the property And-
That would cover the,
Well, I mean, superheats.
consequences.
I'm not sure if that exact point is in the record, Your Honor, but Superheat has suggested that Cypress Midway somehow coaxed the Dahl Trust into selling the property. I mean, there's no dispute this was an arm's length transaction. Cypress Midway became the property owner here, took title to the property. I mean, the Superheat had every right to negotiate something different with the Dahl Trust or try to purchase the property itself in an arm's length transaction. And Cypress Midway paid more for the property than Superheat's purchase option said that it was going to pay for the property. So, I think the answer to your question, I would say, is sort of yes, although it's not exactly in the record that way, but I think it's a reasonable inference from the record. I do want to briefly address our second issue on appeal, if I can turn to that, because
Let's go back to this. So the deal was, we're gonna negotiate this lease, years ago, 2015 or whatever it was, we're gonna have, if this all dies. This is obviously a dispute, but in the permissible extension terms, we get to purchase it at X price. And then now, the property owner is saying, well, unless before this all dies, someone offers me more.
Well,
There's something inherently vicious about that reading on the part of the.
well, Your Honor, under the terms of the trial court's final judgment here, of course, they're still entitled to exercise the purchase option now. Even though
Not under the trial, not under the possible price, negotiated price.
absolutely, they're still able to exercise the purchase option under the terms of the lease. It's simply, our position is simply been discussing the mortgage that, it's subject to the mortgage the property owner recorded on the property. But absolutely, the trial court has found that Superheat has the right to exercise its purchase option under the strike price in the lease.
If you agree that title will be turned over to the terms. Is that correct?
That's correct, Your Honor. And in fact, and this is in the record that we were prepared to make that transfer post final judgment subject to this appeal, but it's the cross appeal as to the other parcel that has been raised that has prevented that transfer from going forward. But we have not challenged the trial court's ruling that they can exercise the purchase option.
You alluded to the fact of the trial court, I think, said would be wholly inequitable. My question is, was there any allegation from undue influence or anything?
There is no dispute, Your Honor, that Cypress Midway validly acquired this property. Again, they have used words like coaxed the trust into selling, the property, but there's no allegation of fraud or undue influence or anything like that. No.
So I don't that anything or to conclusion was self-invention.
I'm not sure if are you referring to the transfer of the property or to the mortgage, Your Honor? There was some.
Yeah, sorry, it's referring to the mortgages.
There was some argument. There's no finding of fraud. There was some dispute about the I'd call it the details of the mortgage transaction, the funding of the loan. And so there were issues raised about that, and they sort of took a position that it wasn't like a valid mortgage or something like that. Trial court didn't make that finding. The trial court did raise a concern about the funding of the loan because the principal of the entities is the same principal. Manchester Commercial Lending is the same principal as Cypress Midway. And so basically, instead of funneling the money through one entity to the other, the principal funded the transaction. I think that's what the trial court was referring to. There's no allegation that this was a fraudulent mortgage, I don't think. Certainly, this is a recorded mortgage in the property record of Hillsborough County.
Can I actually elaborate on that about the purchase money issue? There's one way to characterize it. That the trial court was essentially addressing what would have been a strong argument that would have been made, which is that even if the right option to purchase Superheat's option did take priority, it wouldn't even though it was purchase time because it was a purchase money mortgage. In other words, it was addressing an argument your client could have made, but didn't.
Right, there was some discussion about a purchase money mortgage, because under the law, purchase money mortgage, under the default rules we were talking about before, a purchase money mortgage is a type of mortgage that can sometimes prime another. Right, but our argument really turns on the language. I think that we did make that argument at some point, although we're not really pushing that argument here. Our argument here is based on the text of the subordination clause, but I do think that it was in connection with the purchase money
So that
issue.
This wasn't.
I think that's
It wasn't.
correct, yes, yes.
Mr. Eagleton, you are at your 15-minute point, so use your time as you wish. Just want to.
Thank you, Your Honor. I just wanted to briefly talk about the second issue that we've raised on the option to renew, because, the trial court found here that the lease authorized 2 lease renewals. And again, there is nothing in the lease that could support that finding. The lease has a provision entitled option to renew, singular, referring to 1 extension term, singular, with 1 increase in rent. The only reference to more than 1 extension term is a reference to quote unquote additional 3-year periods, which is plural, although it is followed by another reference to exercising the option to renew, singular. And so under cases like Chess Masters and Stratsky and the other cases we've cited in our briefing, unless a language of a lease clearly and unambiguously compels a finding of a perpetual renewal right, then it's limited to 1 renewal. And so their Superheat's position actually on this was not that the lease authorized 2 renewals, which is what the trial court found, but that the lease somehow authorized them to renew until Jordas Dahl died, basically until they could exercise the purchase option. But that is not what the renewal provision says at all. And we know that the parties understood how to tie their rights to the death of Miss Dahl because they explicitly tied the purchase option to the death of Miss Dahl. The renewal provision here says nothing about that whatsoever. And so for this reason, it's our position that the trial court's.
So let's say that we find it is ambiguous. If and parole evidence was permissible, leaving aside what parole evidence showed, it is the public policy expressed in court opinions for a one-time renewal or.
I think that's right.
Is that come into play in interpreting an ambiguous contract? Or
Well,
should parole evidence indicates that there were indefinite extensions negotiated for. Can the public policy in these reported opinions trump that?
well, I don't, well, first of all, I'd say I don't think so. The Chess Masters case, I think, Your Honor, sort of answers that question because that is a case with a similar provision where the court said it was ambiguous, and because of that, there would only be 1. The court found that it only authorized 1 renewal. But the trial court's finding based on the sort of parole evidence here was that there were 2 lease renewals. That's not.
Do we look at that in terms of hundreds of the evidence, clear and substantial? I'm trying to figure out how to measure parole evidence, because one side says, yeah, we wanted multiple extensions. The other side says nothing clear. Scrivener's error, and the principle of lesser I recall, that's the ambivalence.
Well, before Cypress Midway purchased this property, Your Honor, they received written confirmation from the landlord that the lease only authorized 1 renewal term. They may not have gone forward, frankly, with the purchase if they had been, a contrary evidence from the landlord. But I'm not sure that parole evidence is even really the right analysis here. I think the Chess Masters case is pretty clear that if you want to authorize a perpetual renewal right, then you have to say so clearly and unambiguously. Otherwise, you only get 1 renewal. There's nothing in this provision that refers to the death of Jordas Dahl. There's nothing in this provision that refers to an indefinite renewal right. All there is 1 reference to a multiple 3-year periods, which is in the context of the rest of the provision being in the singular and only 1 increase in rent. And so I just think that the Chess Masters case is really on point here and that there was only 1 renewal authorized.
Sure they considered that seems similar to you, what they consider. This was ambiguous. So I guess your position is that should have more specific language indicate what they wanted to. And because you take the position. Controls.
Absolutely, Your Honor, that's right. And again, we think this is a perfect example of, language that could have been included because we know these parties knew how to tie their right. Their position is that they were allowed to renew until Miss Dahl died. Well, they literally said in the same document in a different provision with a different right that could be exercised when Miss Dahl died. So they knew what they were doing. They did not include that language in this provision, and so therefore Just Masters controls, and there was only one renewal.
Mr. Eagleton, be it out of time.
Thank you.
We'll need it maybe 3 minutes.
Appreciate it. Thank you.
Ms. Ball, you want me to, hit you with 15 minutes so you can see rebuttal time for the.
No, I would like to make sure that I have 5 minutes for rebuttal time. Thank you. Green Moreland, Hilbert Henderson, the client, trial counsel Greg Brown. Also today in the audience is Dennis Newbeck of Superheat there.
Just for the very first issue. How do we get a language in the lease that says this lease is expressly made subject to and is subordinate to all current or future mortgage?
So, Your Honor, there's a lot that has not been talked about in the main appeal argument that we think, to be honest with you, we think the subordination provision is a red herring to this argument, and there is a reason for it. It's very clear in the record that there was no money lent from the mortgage company for the purchase of the property, and that has been conceded. So what mortgage?
Okay.
There was not a mortgage.
I think you're making the argument more like this is a fraud, this is some shady deal.
No.
But that's why I asked the question, and my reading of the record, there's no allegations of, fraud or anything like that. So.
Good fraud, Your Honor.
Okay, so looking at this lease language itself, you said it's a red herring. Why should we totally ignore that language in this lease?
Okay, so assuming for the sake of argument that there is a mortgage, and we don't believe that there is, and that's clear from the record. So the support, Your Honor, we've talked about, was there any case law cited? We cited case law for the proposition that there's nothing in that subordination provision that purports to subordinate a purchase option, which is a legally distinct right from the rights under the lease. The lease has a multitude of rights. There's certain things you can do with the property, the rent, the taxes, et cetera, et cetera. Those are leasehold rights. So the subordination provision, and I think this might go to your point, Judge Atkinson, it's just contemplating if the property were to be transferred, yes, our leasehold rights, the rights and the obligations under the lease would be subject to the new purchaser. A purchase option is a legally distinct right, and we cited the Barco case for that. I know.
Are any of those cases though, in any of those cases, is there a subordination provision that says any and all?
Yes, in those cases, well,
In those cases.
in the three, we cited 3 cases, 2 were from Ohio. So the Barco case is a Florida case. We're not citing it for the facts, but the Barco case said a purchase option right is legally distinct from a leasehold right. That is the principle of law. This is why we say that the subordination provision doesn't address the purchase option. So in the domain.
I thought an option to purchase doesn't spring into effect until it's exercised.
The property right, no, Your Honor, we've actually cited cases for the opposite proposition. A purchase option is a valid encumbrance on property. And we've cited multiple cases for that proposition. And the court talked about that. That's another reason, an independent reason for affirming the trial court. The trial court determined, and this is undisputed, that the mortgage company, assuming it was a valid mortgage, was on actual notice of Superheat's purchase option. First in time is first in right. That purchase option was a valid encumbrance on the property. So in addition to the fact that the subordination provision didn't mention the purchase option, which is a legally distinct right, also the mortgage company had full knowledge that Superheat had the right to purchase the property. And under Florida law, that gave Superheat lien priority, which leads to another argument that, Your Honor, do you have a question?
Oh, I just wanted thanks for my question, that any of the cases that talk about that a right to purchase, an option to purchase being an encumbrance. any of those cases, did the agreement in which that right to purchase appeared to have subordination clause that said any and all provisions of this agreement are subordinated to any liens placed on the property by the owner?
Yes, Your Honor. The two cases we cited, Germain and Four Howards, I believe, Germain talked about that these were Ohio cases. And it said, in that case, I think it was that the subordination provision said, all rights were subordinate, including the purchase option. So that was the language of the Germain case. And in Four Howards, there was a question about whether a right of first refusal had been eliminated by a subordination clause, and the court said no, because the subordination clause didn't purport to eliminate or override, or whatever the language was, to right of first refusal. So we couldn't find a Florida case, but we did find two cases out of state that addressed the issue.
I just was doing research. I found the old Port Cove holdings. There's a Florida Supreme Court case. And it quoted an older Florida Supreme Court case that basically says that in Florida, an option does not create a legal or equitable interest in the property until an optionee exercises the right to purchase in accordance with the terms of his option. So he has no estate, either legal or equitable, in the lands involved, and that answers Judge Rose's question. So, and this is the Florida Supreme Court case, I'm not referring to Ohio.
Right, Your Honor.
Ohio, they do it differently,
Right.
but at least in Florida, that doesn't kick in until you exercise that right.
Your Honor, that's an entirely different issue, which we've also briefed, and it was also briefed in this, before this court in the Upper Deck case, but those cases, so the Old Port Cove case stands for the proposition, it was a rule against perpetuities case. That case, the other two cases they cite, I know they're escaping me now. One had to do with homestead exemptions, one had to do with a government exemption, that was the Leon County case. Escaping these three cases. What they're saying is, you don't have title to property, you don't have an interest in the land until the option to purchase is exercised, but you have an encumbrance. And there is a clear difference between an encumbrance on property, to which the mortgage or mortgagee had notice, and a right to purchase the property or a title to the property. So for example, before you exercise a purchase option in the Leon County case, you weren't entitled to a government exemption because you didn't have a right to the property. In the other case that Hartsfield, I think was the name, you don't have a right to claim a homestead exemption because you don't have a property right. But that doesn't mean you don't have an encumbrance. There are separate cases, and we've cited them, that a purchase option is an encumbrance on property. I mean, that is black letter law. So I understand the court's question, but there is an important distinction between having an interest in the land, which is the Old Port Cove and those cases that they cite, and having an encumbrance on the property. And what's important here for lien priority is the encumbrance, which I would represent to the court we have under Florida law. So that is another reason for affirming the trial court. One, we don't believe there was a valid mortgage, no fraud. We're just saying that they've admitted that the money was funneled through William Haynes directly to the title company. The mortgage company itself never paid the money, and that's undisputed. Two, the subordination provision does not purport to subordinate the purchase option to the mortgage. Again, we've cited case law for the proposition those are distinct property rights, legal rights. We had an encumbrance, first in time is first in right, so we had priority.
And I'm still struggling, if you keep referencing that it's an encumbrance, and I'm looking at the lease that it says all rights. So the fact that it has all rights, wouldn't that include, to use your term, encumbrances, future mortgages, things like that? And as you know, the case law, whatever agreement that has been written, it's an agreement between the parties. I'm having a hard time getting around that language in the lease.
Well, Your Honor, and again, we would say there were multiple other reasons, and we don't think the subordination provision is a dispositive provision. I would just repeat what I've already said. It says all rights under the lease. I mean, that's what it's talking about, the leasehold rights. There is a difference. There is a legal difference between a leasehold right, paying rent, what you can do with the property, et cetera, taxes, and an entirely different fundamental right to purchase. Those are different rights. We've cited cases that support the proposition, not in Florida. Maybe this court will write an opinion that we can cite Florida case law for, but we've cited Ohio cases that support our proposition, our argument. But Your Honor, I would urge the court to look very closely at the record. We're not claiming fraud. We're just simply claiming, yeah, sure, Cypress purchased the property.
But isn't the purchase option a right in the lease?
No, Your Honor, it's a legal right to, it's within the lease. It was written within the lease, but the option to purchase is not a leasehold right. It's a separate legal right.
It's the same.
Correct, it's the same
It's in the same
document,
document.
of course.
And because of the language, it couldn't, if it was your client's position to do exactly what you're advocating, shouldn't they have included that additional language in the agreement?
Well, shouldn't the other side have done that? I mean, so they also in that provision, it said that we would sign any documents that were presented to us to acknowledge a subsequent mortgage, which nobody asked us to do. And I haven't had a chance to raise one more issue that we think defeats this argument.
That just concerned me, that's all.
No, I understand.
Address it.
Your Honor, we're here to argue to the court, so I certainly want to be very clear on that. And again, I don't know what else to say other than I think under the law, there is a difference between a leasehold right and an entirely different option to purchase. Simply because it's in the lease doesn't make it a leasehold right. It's a separate legal right. One thing that has been ignored is in the Manchester mortgage, assuming it's even a valid mortgage. At the end of the mortgage, it said that this mortgage takes priority or superiority over subsequently recorded rents. So the mortgage itself acknowledges that it's only superior to interests that are acquired subsequent to the recording of the mortgage. Sorry.
Thought you might have been brought up at that point. Before you do, could you go back to your point that there is no actual valid lien on property?
Because of the purchase money?
Whatever.
So it's conceded that when Cypress went to purchase a property, Cypress is essentially Bromley. Bromley created a bunch of entities. I mean, that's clear in the record. These are all Bromley entities. So they created Cypress to purchase a property. In real time, they created Manchester Commercial Lending to be the putative lender. And they created Fortaleza, a quote storage company to take over our parcel.
Because Manchester didn't actually lend money to Cypress?
No, and that's undisputed. And Judge Parvante said in the final judgment, there's no source documentation supporting that Manchester ever lent the money. And they've conceded William Haynes, the founder of Bromley, sent 1.5 million from his personal account directly to the title company.
And he did not, he's not a mortgagee.
No,
So if there's a case law that supports that there's no lien on the property in such a scenario in which, let's say we've got entity A as the purchaser, entity B as the mortgagee, but entity C is actually the lender.
well, I don't know if there's case law, but I would say that fundamental to the existence of a mortgage is that the mortgage company lent the money. So Manchester Commercial Lending did not lend the money. So how can there be a mortgage on the property when the mortgage company never lent the money? That is our primary argument for affirmance of this subordination clause argument. The ruling on the subordination clause, and you don't have to take my word for it. It is.
And that doesn't necessarily. That doesn't necessarily have to do with the fact that it's a purchase money mortgage.
Well, it does, because the court said if there was no money lent by the mortgagor or by the mortgagee for the purchase of the property, it follows there can't be a purchase money mortgage.
Okay,
So,
but the purchase money mortgage argument had to do with priority, right? In other words, one argument advanced by Collins counsel, the trial court was, even if purchase option was an encumbrance that predated this latter lien on the property, because it was a purchase money mortgage, it would take priority anyway. And then so the counter argument was, well, that's only if the purchase money, well, you can finish the argument.
right, so we have two responses to that. One is that there is no purchase money mortgage because it's undisputed that the mortgage company never lent the money.
That's more of the general argument, there's no lien at all.
Well, and the second argument is purchase money protection applies where the right is derived from the mortgagor or the borrower. So that wouldn't apply. The purchase money mortgage concept or principle doesn't apply in any case because our rights don't derive from Cypress, which is the putative borrower. they derived from the trust. So we've argued in our brief that purchase money protection doesn't apply for two reasons. One, there wasn't a purchase money, and two, the principal doesn't apply anyway because our rights are not derived from the mortgagor or the borrower.
Borrows purchase money, which aspect of this arrangement, your point is that really just, it's an ephemeral lien, that there is nothing is really leaving the property.
Well, Mr. Haynes is not a mortgage company. I mean, he doesn't have a lien on the property and he's the one that paid the money. So,
This one, didn't the trial court found that the mortgage was appropriate?
no,
And no, the court found that it was legit, that the action was legitimate. And that, if you look at that, I don't think the court came to the conclusion. I'm pulling up the order.
Your Honor, it's not a question. Well, no, it is. I mean, you use the words, was the mortgage legitimate? So that,
Court basically said it would be inequitable. So
Well, that-
made the finding that, hey, it's fair. And so I guess I'm looking at it, okay, that was mentioned. And so I'm just concerned with your argument that just because there was no money lent, that somehow this was a fraudulent kind of mortgage. I go back to that, but this is basically your argument that this is. There was no such thing. Court, and so the court basically, as I read that he did accept that there was it would be wholly inequitable to allow it.
So it's not a question, Your Honor. We're not saying whether it's and we're saying it doesn't exist. So it's sort of like void.
This is where,
But
this is where I'm having problem, because if you were questioning, if you had a dispute as to that portion of the finding, shouldn't you have brought that as on appeal? That the judge was wrong in having accepted the fact that the mortgage existed. The judge just simply went one step further and found it inequitable. But now you're arguing post on appeal, well, this is, this is not right. It's almost like you're making a fraud argument that there's no money lent and therefore it's a non-existent mortgage, but that's not what was below.
so, yes, Your Honor, we're not, and again, there's nothing to appeal because the court got it right. We're not saying it was a fraudulent mortgage. We're saying there was no mortgage. A mortgage contemplates that a lender actually lends money for the purchase of the property. And I'm sorry that I had to page through this final judgment. But on page 19 at paragraph 28, the court went on to say purchase money protection applies only to the amount of the proceeds actually used to acquire the property. All of the competent evidence suggests that Manchester did not lend any money for the purchase of the
Well, when he says
property.
purchase money, he or she, sorry, I'm trying to work, says purchase money protection. Is that? In other words, the protection, you're saying that there's no lien at all.
Well, okay, then the
In
paragraph,
that context, this purchase money protection, it sounds to me that the trial court is talking about the prior issue.
right, so if you want to look on that context, you want to look at the sentence ahead of that, paragraph 27. If Manchester were able to prove it actually lent purchase money proceeds, well, that's what they are, purchase money proceeds. That's what a mortgage company would typically provide. It did not lend those proceeds to a trust and therefore cannot prime supersedes purchase option. It goes on to say, I mean, I don't know how else to say this other than that the court throughout, or not throughout, but in various parts of the final judgment, it wasn't a question of whether, we don't care about the mortgage. We don't care whether it was valid or fraud. There wasn't a mortgage. And the court made very clear, and this is at paragraph 28 and paragraph 29, all of the competent evidence, Judge Barfonte said, shows that Manchester did not lend any money for the purchase of the property. I mean, should he have then possibly said, therefore, there was no mortgage? I think it's kind of like, well, the sky's blue. We all know the sky's blue. There's no reason to have to say that. If you don't lend money, how can you have a lien on property? And that's what he was saying. So he goes on to say, Cypress and Manchester failed to produce any source documentation evidencing that Manchester lent any money for the purchase of the property and conceded that it did not. So,
If I may, we have peppered you up to 18 minutes of your
oh
time.
gosh, okay.
To take a minute or two and tell us about cross, and of course, we'll give you something.
Okay, well, we never talked about the lease renewal, and I will just say on that subject, on the lease renewal terms, one, it said periods. So obviously there was gonna be more than one lease renewal period. Everybody agrees that we had at least one lease renewal period. We exercised the purchase option before the second renewal term. At that point, we became the equitable owner of the property. Court said that in the final judgment. That finding has not been challenged on appeal. So again, it's kind of a red herring, this whole notion that we didn't have multiple lease renewal terms. We did, and nobody was saying there was gonna be in perpetuity. Everybody knew, and it's clear from the lease, that it was until Mrs. Dahl died, and Mrs. Dahl was well into her 90s at the time. So anyway, I just didn't want to. So the cross appeal issue, I had wanted to, I don't know if I have time to provide a little bit of background, but I will just say that when this case was tried, it was clear to everybody that we were all talking about the same property. And that property was parcels A and B that were described on Exhibits A to the Broadmoor omnibus lease, the Cypress purchase agreement, the Manchester mortgage, the special warranty deed. Everybody agreed it's parcels A and B. Cypress filed a counterclaim, said we're all disputing whether, it wasn't whether appellants had more property than we did. It's whether we had the right to purchase the property that they purchased. And so that's what was tried. And those descriptions, and that's what Judge Marfonte had to do at trial. He had to see, okay, well, the super lease only said 3654, but later it said 3652, didn't have a legal description. So he looked at all the evidence, including and especially what the appellant's document said, and he came to the conclusion that we had the right to purchase parcels A and B. That's the exact same parcels A and B that Cypress purchased.
I think you were able to show, and I think there's some confusion, I think, on the judge's part. Because the property appraisers, the different, there's discrepancy and things. But from what I understand, that the evidence submitted, and yet verifying that the 3650 West Cypress Street address never existed in the property appraiser's records before trial. And that the 3650 tree parcel is within parcel B as lot 182. Therefore, it's part of the purchase option under the final agreement. And that the entire West Cypress Street rectangular property includes a lot 182, which is the tree parcel, and that is part of your purchase option. And so I think where he had confusion, you have it was all along part of the whole thing. And I think where the discrepancy is, the judge just focused on one thing because it was an area or the other. But ultimately, as I see in the record, you're all able to show that that was together.
Correct, Your Honor. Your Honor has made our argument for us. Judge Marfonte, with all due respect, was either confused, hung up on whatever you want to say on a street address. But the evidence was the evidence. It was not challenged on appeal. The evidence was that was part of parcel B. That's part of our purchase option. So we're just asking for reversal on this small issue of my client's right to close on the entire rectangular parcel of property, which would include the bank of trees, the 30-foot bank of trees on parcel B, which is lot 182, and therefore part of our purchase option. And if I have any more time left, I'd like to a few minutes for rebuttal. Thank you.
3 minutes. You're Eagleton,
Okay, Mr. Eagle, and I'm welcome to focus, because I
can't even get to the public.
make sure we get. It appears that the lot 382 street address, final view of the record, was changed. 3652 to 3650 on the property appraisal website after the entry of the final judgment. And so even though the city's records had the 3650 address previously, I think everybody focused on the property appraisal's records and trial and did not really address the city's contrary designation. And so, as my question to Ms. Borland, it appears that all of those were together. How do you respond to that?
Well, I think, Your Honor, when I want to step back for 1 second. So the issue in this case is Super Eats purchase option and what does it encompass? The purchase option does not say anything about lot 182. That is not in the purchase option. Purchase option says Super Eat has the option to purchase 3654 West Cypress Street, uses an address. That's all it says. that address refers to the back building on this lot, which makes sense because that's the building that for many years, until they vacated it, Superheat was occupying. So our position was the purchase option is limited to what it says, 3654, the back part of the property. Their position was, no, it also includes the front part of the property, because there's a building on the front of the property too. Parties were talking about parcel A, the front, parcel B, the back. And so we said, no, 3654 means 3654. So in order to add 3652 West Cypress Street into this purchase option that's talking about 3654 West Cypress Street, they presented evidence at trial, property records, that showed that 3652 and 3654 shared the same tax folio. There was no plot line on the records that distinguished between those two properties. And so therefore they said, well, that means that 3654 includes 3652 because these are actually the same. That same evidence, this is what Judge Farfante found post-judgment. Their evidence, the exact same evidence he considered at trial, says the opposite about 3650 West Cypress Street. I mean, they're calling it 30 feet of trees to try to conjure up some image of like a worthless piece of property. This is the piece of property that's prevented the whole transaction from closing. That's in the record. So I don't think it's worthless at all. There's no evidence in the record that this is a worthless piece of property. She referred to it as a small issue. I don't think it's a small issue, or we wouldn't be here on a cross appeal and this transaction would have already closed. Judge Farfante found that if they wanted to talk about 3650 West Cypress Street, they had every opportunity to do that at trial. All this post-judgment presentation could have been made at trial. His order finds a waiver post-judgment, which is a finding that's entitled to deference.
And looking at in the record, then how come in the counterclaim, Cypress Midway expressly asserted that quote, parcel B of the property includes lot 182?
They were referring, I think at the time, Your Honor, to subsequent documents that included legal descriptions of the parcel. So there's no dispute that when Cypress Midway acquired the property, their real estate documents included legal descriptions, and that Cypress Midway acquired from the Dahl Trust lot 182. And so I think that that's what that reference was about. It may have been inexact at the time that the counterclaim was filed, I'm not sure, but there's no dispute that at trial, the position taken was that the purchase option covered only 3654 West Cypress Street. Parcel B is not something that's listed in the purchase option either, Your Honor. The purchase option is for 3654 West Cypress Street. And so our position on the cross appeal is, and Judge Farfante made these findings, I think that they're factual findings, frankly, post-judgment, that are entitled to deference. That the only reason that, and I want to say too, their witnesses, when they were making the evidentiary presentation at trial about trying to get 3652 included in the 3654 purchase option, and they were saying, well, there's no plot lines between these two parcels, they acknowledged the existence of plot lines between the third parcel, the 3650 parcel, but they didn't deal with that at trial, which I think is what Judge Farfante was then saying post-judgment. You had every ability during the trial, Superheat, to argue if you thought your purchase option included this other separately demarcated parcel, to include it in the purchase option. You could have presented all of this evidence, including, the testimony that 3650 has always had its own address. Post-judgment was from a city of Tampa witness who was a neutral witness called by Superheat, who said this has always had its own address.
Didn't the final judgment Superheat's purchase option covered parcel A and B, correct?
Yes, it did.
All right. And we know that lot 182 is on parcel B, which you accept that.
I think that is true, yes, Your
Okay.
Honor.
And so before trial and pre-trial, the property appraiser's website included 182 under the 3652 address, correct?
Yes,
Okay. Did not include the 3650 address at all, but then post-judgment, the property appraiser created the 3650 address for lot 182.
well, the property appraiser didn't create that address, Your Honor. The testimony from the witnesses in the post-judgment hearing was that that address has always existed. The property appraiser simply, it looked like it was created because there was now not going to be common ownership of the property. So it's the property appraiser's policy that when there's common ownership, they're not focused on this. And so what Cypress said was those parcels are no longer going to have common ownership because we own 3650 and Superheat's going to own 3652 and 3654. So Cypress simply requested that the property appraiser display now, because there was not going to be common ownership, a distinction between those addresses. But the evidence was clear. Judge Farfante made this factual finding that 3650 West Cypress Street is an address that has existed since 2004. And the city of Tampa witnessed.
I appreciate that. The city's record included 3650 address for lot 182. It wasn't from my review of the record. So that was I feeling of keep the contract was. The city's record.
Well, I think he focused on the records that Superheat presented at trial, Your Honor, right? Because looking at paragraph 7 of the final judgment, right, this is page 5. It says that when we were discussing, you know, whether the purchase option covered 3654 or also 3652, Judge Farfante said he's looking at a printout evidencing that both the front building and the back parcel include a same folio number and address. So he was focusing on those records in the plot line and tax folio because those were the evidence and the records that Superheat was presenting to try to, in our view, bootstrap the 3652 property into the 3654 purchase option. So it's our position that there were 3 parcels here. The purchase option said they get one of them, 3654. The trial court gave them another one, 3652. And now they're asking for a third one, 3650, when they have a purchase option that just says they're entitled to 3654. So we're obviously not here challenging anymore 3652, but we are saying that they don't get all 3 of them. And they never argued for 3650 at trial. Judge Farfante made that ruling post-judgment. That's a factual finding. He relied on their evidence, the same evidence that he relied on at trial. Is the evidence that he looked to in the post-judgment order to say that 3650 is not included in the scope of the purchase option. I'm sure I'm long out of time, Your Honor.
Or generous.
Thank you.
Thank you. Ms. Borland, you be generous.
Well, I appreciate that, Your Honor. And again, Judge Kazam, you have made the point. And the point really is, and this dispositive point is that lot 182 is part of parcel B and parcel B is part of Superheat's purchase option. Now, counsel seems to be wanting to relitigate how parcel B, how it came about that Judge Farfante ruled that Superheat was entitled to purchase parcel A and B, but that is now not the case. It has not been appealed. And that was done by reference to lots of things, not just lot lines and folio numbers. There isn't a third parcel. I mean, as the court has already recognized, there's 2 parcels, A and B. B includes lot 182, and the record is undisputed, and they have conceded that lot 182 is a tree parcel. It is as simple as that. And again, with all due respect, I'm not saying this is a small issue. This is a big issue. It was a small error. It was a small error on the part of Judge Farfante and an otherwise very robust final judgment that we agree with. But it's very important to our client. It is part of our property. It is supported by the evidence that we're entitled to this property. It was this 3650 address that was created by appellants after the judgment that caused this confusion. And so we would respectfully request that the court affirm the final judgment on the main appeal for all of the reasons we've argued, but reverse this post-judgment order determining that our client does not have a right to purchase lot 182 within parcel B. Thank you.
Thank you, Ms. Borland. Thank you both. Very well argued, interesting case.
I totally agree with Judge Rose.